We are diving deep today into a story where, well, the immense hope of prospective parents kind of collided with a really devastating financial scheme. This deep dive is all about the anatomy of adoption fraud. We're focusing on the case of Simone Swenson, who ran a Houston area adoption agency, and how she went from facing lawsuits to actually serving time in federal prison. What we've got in front of us are, court documents, testimony from victims, families from all over the U.S. actually, and the appeal court rulings that really cemented what this case means legally. It wasn't just like a business that failed. The core allegation was a betrayal of absolute trust.
Yeah, and the central mechanism, the thing that was so devastating for the 6 couples who first sued, was this practice called double matching. I mean, imagine you sign up, pay a lot of money, thinking you have an exclusive match with a birth mother, only to find out later she was sort of simultaneously offered to other hopeful parents too, and everyone's paying these huge non-refundable fees.
Exactly. So our mission here is to trace that whole legal journey. How do you get from civil complaints about misrepresentation all the way to federal mail fraud charges? And crucially, what did the courts decide about the vulnerability, the emotional and financial vulnerability of the people caught up in this?
Okay, let's set the scene a bit. The agency was the Sans Perel Center for Children and Family Services. It was in the Woodlands, just outside Houston. Simone Swenson was the administrator, and by early 2014, the agency had actually already shut down its services. Swenson was claiming that the accusations, the negativity, had just become unbearable.
Right. And the first sort of wave of legal action was civil. We had 6 couples
Yeah.
from Georgia, Illinois, Missouri, Nebraska, New Jersey, quite widespread. They came forward accusing the agency of, well, negligent misrepresentation, basically, and violating the Texas Deceptive Trade Practices Act. They weren't just saying, oh, our adoption fell through. Their claim was specific. We paid thousands for an exclusive match, and it wasn't exclusive at all. And the money involved, that was a huge part of it, wasn't it? Clients were shelling out tens of thousands of dollars, like $20,000, $30,000 sometimes, all as a one-time, non-refundable agency fee. Didn't matter if you actually ended up with a baby or not.
And Swenson's defense against those early lawsuits is really telling when you look back. She flatly denied any double matching.
Sure.
Her argument was essentially, look, adoptions fall through. It's a risk. Birth mothers change their minds. Maybe they're talking to other agencies. She painted it as just, the common heartbreak of private adoption. And she insisted that the fee, that big non-refundable fee, it just stays intact so she can keep working on finding another match if the first one fails.
So she was basically trying to frame herself as, what, just a victim of bad luck, difficult circumstances, and a tough business?
Yeah, and I remember reading, she even sort of suggested that clients were maybe too focused on the transaction side. She said her focus was the child, while clients were just looking for children. That sounds a bit dismissive. It really clashed with what was actually happening, though, because you have 6 couples, 5 different states, all describing such similar experiences. It started to look like a pattern. And it wasn't just the lawsuit. The local DA's office, Montgomery County, they started getting complaints too, lots of them. The prosecutor, Nicole Tchaikovsky, she pointed out this consistent theme. People paying, as she put it, a tremendous amount of money, and there are no babies.
Okay, so if Swenson's story was, this is just the normal risk of adoption, why bring in the DA and then the FBI? I mean, when does poor business practice cross the line into actual crime?
And that's the absolute crucial legal pivot point here. Swenson could argue bad management, maybe negligence, maybe even breaking contracts as civil court stuff. But for criminal charges, especially federal ones, which the FBI handled because the victims were in different states, they had to prove intent, intentional fraud. They had to show she knew she was taking that money under false pretenses, that she was telling families they had an exclusive match when she actively knew it wasn't true. That elevates it way beyond a business dispute. It becomes a scheme to defraud.
Right. So let's dig into how the indictment actually described the fraud itself. This was apparently happening between January 2013 and January 2014, and the total amount collected illegally just within that scheme was estimated at around $111,000.
Yeah, the indictment really broke down how she allegedly exploited the agency's own financial processes.
Yeah.
Step 1, require these massive agency fees, plus any expected birth mother expenses paid up front, before really moving forward. Then step 2, once the money's in the bank, she allegedly becomes hard to reach. vague updates, if any, and crucially, often failing to provide invoices or receipts. So families had no idea where their money meant for, say, a birth mother's rent or medical care was actually going.
That $111,000 figure is staggering, but numbers can feel abstract. How does that connect back to the human cost, the emotional betrayal? Is there a specific example that really highlights well, the cruelty of it?
There is. And this specific instance involving a couple named Nidrick and a birth mother named Ashley Smolt, this became central to her eventual conviction. So Anise and Jason Nidrick, they were a couple from Missouri. They get matched with Ashley Smolt. In September 2013, Swenson asked them for $1,800 to cover Smolt's expenses. Now, here's the key part. They were rolling over their existing agency fee, about $11,700 from a previous adoption attempt with Sans Pareil that had already failed. So they weren't just invested financially, they were emotionally reinvested after a prior heartbreak through the same agency.
Oh, wow. So they'd already been through one failed match, paid that huge fee, and were basically doubling down, putting all their remaining hope and funds into this one chance.
Exactly. Deeply invested. And right at that moment, according to the evidence, the double matching was in full swing. Swenson had apparently also matched Ashley Smolt with another family, Daniel and Christopher Cuscieri, simultaneously. I mean, this is the textbook definition of intentional deception in a situation where people are incredibly vulnerable.
And the way it played out, it's almost hard to believe. When Smolt actually gave birth and she had chosen the Niedriches, she wanted them to adopt her baby. Swenson apparently lied to her, told her right after she delivered that the Niedriches had backed out, just changed their minds. But conveniently, the other couple, the Cuscieris, were supposedly waiting right there at the hospital ER.
Can you imagine? Smolt, in that incredibly vulnerable moment post-birth, being told this. She's apparently confused, upset, and she ultimately decided right then she couldn't go through with it under those circumstances. She decided to keep her baby because the only family she had agreed to place with, the Niedriches, were supposedly gone. The layers of harm here? It's staggering. The prospective parents are cheated and heartbroken. The birth mother is manipulated emotionally at arguably the most sensitive point in the entire process.
And Dr. Anise Nidrick, she testified later about the financial devastation, said this whole ordeal completely wiped out their savings. She also talked about concerns over how the birth mother, Smolt, was treated. Allegations that maybe she wasn't getting to doctor's appointments or didn't have enough food, even though the Niedriches had paid funds specifically meant for her care. Swenson denied those specific claims, but it points to this complete breakdown of trust and responsibility.
And, before we even get to the criminal trial for the adoption fraud, it turns out this wasn't Swenson's first issue with handling money that wasn't hers. Connecting the dots here. Back in August 2012, before this specific adoption scheme really ramped up, regulators had already revoked Sans Pareil's license for foster care.
Wait, really? A foster care license? What was that about? Was it related?
It showed a pattern, definitely. Regulators found she'd misused funds meant for foster families. Money explicitly provided for the care of vulnerable kids was allegedly used for her personal expenses. The findings specifically mentioned mortgage payments and, get this, visits to the nail salon. So that detail suggests this blurring of lines, treating agency trust funds like her own personal bank account, might have been going on for years.
Okay, that context makes the federal indictment in July 2015 feel, well, almost inevitable. She was charged with 4 counts, right? Mail and wire fraud. Because the money and communication crossed state lines, involving victims in different places.
That's right. The federal angle was key. And after a trial in September 2019, a federal jury convicted her. Not on all 4 counts, but on 2 counts of mail fraud. And importantly, the jury clearly rejected her story. They didn't buy the "I was just negligent" or "ran a bad business" defense. They found she acted with intentional criminal fraud.
So the sentence came down in September 2020. She got 24 months, 2 years in federal prison, plus 3 years of supervised release afterwards. And she appealed, didn't she? Tried to argue there wasn't enough evidence for the conviction. That led to the Fifth Circuit Court ruling in 2022.
Yes, and the appeal got a bit technical, focusing on one specific aspect of the mail fraud conviction. It related to that $1,800 check from the Niedriches for Ashley Smolt's expenses. Swenson's argument was basically, hey, they eventually got that check back, it was returned uncashed, so no actual loss occurred from that specific check, therefore it can't be mail fraud.
But the appeals court didn't agree. They upheld the conviction anyway. How did they square that?
They looked at the bigger picture. The Fifth Circuit said the crime wasn't just about whether that single check ultimately cleared or caused a final loss. The crime was using the U.S. mail as part of an ongoing fraudulent scheme. The act of soliciting that $1,800 payment under the false pretense of an exclusive match that she knew wasn't exclusive, and having that solicitation and payment travel through the mail. That was the mail fraud. The fraudulent intent, the scheme itself, was already established. The mailing of the check was just one step within that illegal scheme. So the conviction stood. Okay, and this brings us to perhaps the most legally significant part of this whole case, which came out during sentencing. The judge applied something called a sentencing enhancement, basically adding to the severity level, because the crime involved what the law calls an unusually vulnerable victim.
Right, that term vulnerable victim, it carries a lot of weight legally. We often hear it applied to, say, crimes against the elderly or people with disabilities. How did the court define the vulnerability here? What made prospective adoptive parents unusually vulnerable in the eyes of the law in this case?
The court's explanation was really specific and quite poignant, actually. It recognized the unique emotional state of these families. The judge found they were vulnerable, and I'm quoting loosely here, by virtue of desperation and extraordinary hope, a hope so strong that might blink at experience or, ignore warning signs. The court basically acknowledged that the deep fundamental desire to build a family can overwhelm normal caution, especially around finances.
Wow. That's a really powerful legal acknowledgement. It reframes adoption, at least in this context. It's not just a service contract. The court called it an odd business transaction, one involving essentially the purchase of a baby, their words, to make that baby a member of a beloved family.
Yeah.
And the implication was that Swenson, with her years of experience, absolutely knew about this heightened emotional state, this vulnerability, and exploited it.
Exactly. And this vulnerable victim finding also directly impacted the financial penalties. Remember, the Kukuris, the other family matched with Ashley Smolt. Swenson was ordered to pay them $26,550 in restitution. Now, interestingly, that amount included an earlier payment of $13,400 they had made, which was actually linked to one of the fraud counts Swenson was acquitted on.
Wait, hang on. How does that work? If she was found not guilty on the count related to that first $13,400 payment, why did she still have to pay it back as restitution? That seems odd.
It does seem counterintuitive at first glance, but the legal reasoning connects it all back to the overall scheme. The court basically said, yes, she was acquitted on the specific charge tied to that initial payment. However, that $13,400 payment didn't just disappear. It was subsequently rolled over, used as credit towards the later fraudulent match attempt involving Ashley Smolt, the one she was convicted for scheming around. So the court ruled that losing that initial $13,400 was a direct harm the Kukuris suffered as a result of the overarching criminal scheme, even if the charge for receiving it initially didn't stick. It ensures the victims are compensated for losses directly flowing from the whole pattern of deception, not just isolated counts.
So this case serves as this really stark, painful reminder that the intense emotions wrapped up in adoption don't just create hope, they create this unique kind of vulnerability.
Hmm.
And sadly, that vulnerability can be weaponized by people committing fraud, leading to just devastating financial and psychological harm.
Absolutely. And I think the biggest takeaway, legally speaking, is that formal recognition of prospective parents as potentially unusually vulnerable. When you have a life-altering goal, like having a child, intertwined with a complex, expensive business transaction, the law is acknowledging here that the people involved aren't just typical consumers. They are operating from a place of profound hope and need, making them exceptionally susceptible. That sets a really important precedent for how we view fraud in these deeply personal, high-stakes situations.
Right. And considering everything we've discussed, the huge sums of money, the manipulation, the recognized vulnerability, it leaves us with a final thought for you, our listener. What kinds of specific, maybe even specialized safeguards should the state or maybe regulatory bodies put in place to protect these unusually vulnerable consumers, especially when they're navigating something as high stakes and personal as private adoption? How do we ensure that hopeful parents are shielded from becoming just targets, just seen as a source of, well, liquid savings? Something to think about.